Underhill in the matter of Lewis-Ranwell and G4S Healthcare Ltd.
May it please your ladyship and my lady and my lord, I appear on behalf of the Fourth Defendant or Third Appellant, Devon County Council, along with my learned friend, Mr. Jack Harding. My learned friend, Ms. Judith Aileen, one of Her Majesty's Council, appears for the Third Defendant, the Second Appellant, the Health Trust, along with Mr. James Goodcamp. My learned friend, Mr. Gurian Tosag, appears on behalf of the First Appellant, First Defendant, Mr. G4S. And my learned friends, Miss Selina Plowden, one of His Majesty's Council, and Mr. Christopher Johnson appear on behalf of the respondent of the court.
And thank you very much for organising the time efficiently in relation to the 2 days that at the moment we think this case is going to take to be argued.
Yes. I'm fairly optimistic that it should prove to be comfortable.
Yes, it would be rare for a case on appeal to take longer than it did
Yes.
below. It's not going to be one of those rarities.
No. My ladies, my lords, on the 10th of February 2019, the claimant, Mr. Lewis-Ranwell, killed 3 men whilst in a psychotic state. Those men were Anthony Payne, whom he bludgeoned to death with a hammer in his own home, and 2 brothers, Dick and Roger Carter, whom he killed in their home using a spade. He carried out the killings whilst under a psychotic delusion that he was on a mission to kill paedophiles and that these men were paedophiles. It is, of course, important to be clear that they were not, and they were entirely innocent victims of the violent attacks. As for who the defendants are, the first defendant, the first appellant, but if you don't mind, I'll refer to the parties by their status in the proceedings below, performed custody services on behalf of the Devon and Cornwall Police and employed healthcare professionals and a force medical examiner. The second defendant, or the police force who had taken Mr. Lewis-Ranwell into custody in the days, indeed the day before the attack, and released him, although they have pleaded that the claim is barred by illegality, they're not parties to the current application. The third defendant is the Mental Health Trust, who employed a liaison and diversion team whose role was to identify people in the criminal justice system who needed mental health assessment. And the fourth defendant, my clients, were the local council, which employed approved mental health practitioners, that is approved under the Mental Health Act 1983, and an improved mental health practitioner coordinates Mental Health Act assessments where requested in their area and where appropriate, having received recommendations to that effect from approved medical practitioners, or if they then receive recommendations to that effect from approved medical practitioners, they may make an application for somebody to be committed to hospital against their will under sections 2 or 3 of the Mental Health Act. The essential facts are as follows. Mr. Lewis-Ranwell had been arrested and taken into police custody on 2 occasions in the days preceding the killings. First, on the 8th of February 2019, for burglary. During his first time in custody, he was assessed by a healthcare professional employed by the first defendant, and on her recommendation, a senior mental health nurse employed by the third defendant. The nurse found that there was no current role for mental health services, and the claimant was charged and released on bail. He was taken by the police to the Freedom Centre, which is a hostel. This was all in Barnstaple. in Devon. After a few hours, he left the Freedom Centre and assaulted a farmer. He was arrested for the offence of grievous bodily harm, and on this occasion he was seen by healthcare professionals from the First and Third Defendants. A senior mental health care professional from the Third Defendant, that's the Trust, also assessed him over the telephone. An employee of the Fourth Defendant was contacted about logistical arrangements for a potential Mental Health Act assessment in the event no such assessment took place. Mr. Lewis-Ranwell was then released by a doctor employed by the First Defendant, was then assessed by a doctor employed by the First Defendant on the evening of the 9th of February, who found that he was not suicidal or psychotic. He had a discussion with the approved mental health practitioner employed by the Fourth Defendant, and the outcome was a decision not to assess him under the Mental Health Act. The police later released him, a superintendent having decided that there were not sufficient grounds to extend his detention in custody under the Police and Criminal Evidence Act 1984 for further investigation of the offence before charge. Upon his release, Mr. Lewis-Ranwell travelled to Exeter by a combination of taxi and rail replacement bus, and he committed the killings by going into the victims' houses, acting under the delusion, as I have mentioned. He was arrested and charged with murder. In the Crown Court, the jury returned a verdict of not guilty by reason of insanity, on the grounds that he did not know that what he was doing was unlawful by reason of a defect of his mind. As prescribed by law under the Criminal Procedure Insanity Act, Section 5, as a result of that finding, he was made the subject of a hospital order and a restriction order. He is and has been since detained in Broadmoor, where he will remain until such time as both those treating him and the Secretary of State for Justice, or alternatively the Mental Health Tribunal, are satisfied that he no longer poses a threat to the safety of the public. Mr. Lewis-Ranwell brings these proceedings against the four defendants at common law and under the Human Rights Act 1998. In terms of his common law claim, he alleges that the defendants were negligent, either singularly or in combination, in not having had him assessed for compulsory detention under the Mental Health Act 1983. And although the sections aren't mentioned in the pleadings, presumably that means under either sections 2 or 3 of that act. He says that but for their negligence, he would have been compulsorily detained and treated under the Mental Health Act for up to 6 months, and that he would not therefore have killed the men. He claims compensation for the losses he has sustained by reason of the fact that he killed the men. I'll not take you to it unless you want me to, but they're in the schedule, which is in the supplemental bundle at page 1. But it's in essence, and in summary, what he claims are damages for loss of his liberty because of the fact that he is detained in hospital. He claims general damages for the distress and remorse which he says he suffers as a result of the killings. He claims damages for loss of his reputation. He claims consequential loss of earnings, and he also makes a claim for gratuitous care, which he says he will need on his release from Broadmoor. He also makes claims for legal costs, including potentially deputyship costs to make applications to the Mental Health Act Tribunal for his release. And he also seeks an indemnity against claims made against him, should any be made. In fact, more than 3 years have elapsed and there aren't any. The issue, the appellants have applied to strike out the common law claims insofar as damages are sought consequential to the killings. I do emphasise that because it doesn't appear from the judgment below, but they accept insofar as there was any psychiatric injury prior to the killings, they would be liable for that, but it's all damages consequential on the killings that the appellants sought to strike out. And the issue on the appeal is whether Mr. Lewis-Ranwell's common law claim, insofar as he seeks damages consequential on his killing of the 3 men whilst insane, is barred by the illegality defence. The issue is not one which the appellate courts in this country have had to decide before.
Can I just ask one question?
Yes, of course.
The judge says that it conceded that the illegality defence doesn't apply to the Human Rights Act claim.
Yes.
So what does that mean in practice?
Well,
if you succeed, will those claims go ahead and won't they raise all the same issues?
Well, the Human Rights Act claim raises a whole host of different...
Obviously different legal issues,
yes.
But isn't it all the same damages arising out of the same facts?
Well, the reason there is an advantage in these proceedings is that there's a question mark as to whether, in fact, there is a good claim under the Human Rights Act at all in relation to a claim brought by Mr. Lewis-Ranwell. There's a different threshold for liability. There's a different set of rules governing that claim. And the issue which would arise on the Human Rights Act claim in relation to damages is that although there is Court of Appeal authority that the ex terpi causa defence is not a bar to a Human Rights Act claim, this court did say that it could nonetheless be a relevant factor in determining whether damages were necessary for just satisfaction.
I didn't pick up what all that authority was.
It's just gone out of my head.
It's not one of
Al Hassan Daniels.
Not one of the ones we've got.
No, Al Hassan Daniels.
give
But
me
we'll
the
make
reference?
sure you get a copy of that.
Yeah.
Al Hassan, AL-HASSAN
Okay, if we're going to get it.
Daniels. And it's a decision of this court. I think Lord Justice Sedley gave the judgment from memory. So what that case said is looking at cases like, I think it was the shooting of the IRA people in Gibraltar. The fact that you were engaged in illegality didn't necessarily bar a claim. It could be relevant to the question as to whether there was just satisfaction. And it might also be relevant to ask whether any losses you suffered were caused by your own act or by the breach of human rights. The facts of Al Hassan Daniels were that somebody had been arrested and brought into custody, and whilst in custody swallowed a large quantity of drugs, as I recall, or had a large quantity of drugs when they were taken into custody, but refused to allow the police.
Don't worry, I just wanted to understand what the consequences of your succeeding on this appeal, if you do, would be about whether the proceedings would continue, and the answer is they would continue.
They would continue, but under a
unless they chose not to.
Yeah. But they would continue, but under a very different legal framework is the answer.
And perhaps while I'm on this, what is the position about the police who plead this point but didn't raise it as a strikeout?
Well, they're in the comfortable position that if the claim is barred by illegality,
in practice, they can then jump on the bandwagon.
Well, they will benefit from it because illegality is it's not dependent on the parties taking it. If the claim is barred, it's barred. Yeah. So one can see the tactical wisdom in their position.
They just trusted you, Mr. Walnut, to say everything their counsel would have said.
Well, I don't know about that.
Okay, thank you.
My lady, my lords, as I say, it is an issue which the appellate courts in this country have not had to decide before. In Grey and Thames trains, which we will come to, and in Henderson and Dorset Healthcare, which we will also come to, the House of Lords and the Supreme Court have barred claims brought by claimants who had killed during a psychotic state, but who had pleaded guilty to manslaughter by reason of diminished responsibility. In both cases, the disposals by the Crown Court was a hospital order with a restriction order. In Ms. Henderson's case, the trial judge had had the option of imposing a penal element under Section 45 of the Mental Health Act, but decided it was not appropriate to do so. And he held that Ms. Henderson should not be regarded as having significant responsibility for what she had done. I say the trial judge, I mean the trial judge obviously in the criminal proceedings, Crown Court judge, it was Mr. Justice Foskett. So the only point of distinction in this case, and the issue for this court, is whether it is a determinative point of distinction, is the finding of insanity. In all other respects, the cases are the same. My lady, if it helps, my lord, to give a broad overview of what my submissions will be.
Yes, thank you.
My first submission will be that the overarching submission is that the illegality defence is at heart a rule of public policy concerned with ensuring coherence and consistency in the law. And secondly, the defence applies not just to acts which are criminal, but acts which are quasi-criminal, or, to quote Lord Sumption, engage the interest of the state or the public interest. Thirdly, we submit the killings in this case fulfill those criteria. Although the respondent was acquitted, his was not a full acquittal, but a special verdict. The actus reus and indeed the mens rea for murder were present. The Crown Court had to impose a prescribed disposal of indefinite detention in a hospital for the benefit of public safety. And finally, we submit in these overarching submissions that applying the trio of considerations set out by the Supreme Court in Patel and Mirza, the considerations for denying the claim should lead to its denial, as indeed they did in Henderson. The structure I propose to take, with my lady's leave, is to take the court through the law on the nature and consequences of a finding of insanity, and are looking at the criminal law. We have also identified a case on coronial law, which we feel we should draw to the court's attention. I'll take you to that. And civil law. I then propose to go to the key, or what we submit are the key House of Lords and Supreme Court cases on illegality, looking in particular at Grey and Thames Trains, Les Laboratoires Servier and Apotex, Patel and Mirza, Henderson and Dorset Health Authority, and then I propose to take you to the New South Wales case of Hunter Area Health Service and Presland. And then in the final section of my submissions, I would propose to go to the judgment and our grounds of appeal against the background of that law.
Yes.
My lady, turning first to the insanity defence, the court will be very familiar with it. There are two limbs which were set out in McNaughton's case, and of course the court will be familiar with the rather unusual circumstances of McNaughton's case. It wasn't a formal judgment in the case itself, but the judges were summoned to the House of Lords to answer questions, essentially to explain themselves about the decision of insanity that had been reached. in a case involving someone who'd attempted to assassinate Sir Robert Peel. We have the opinions which were given to the House of Lords at tab 6 of the authorities bundle, at page 47 of the bundle. And the key passage, which has been taken to be the law of England and Wales from the point of view of the insanity defence in criminal proceedings, is at page 51. And taken from the judgment of Chief Justice Tyndall. And it's on page 51, towards the last paragraph on the page, about the proper question to be asked of the jury, where a person alleged to have been afflicted with insane delusion respecting one or more subjects or person is charged with the commission of an offence, of a crime, murder, for example, and insanity is set up as a defence. And then thirdly, in what terms ought the question to be left to the jury as to the prisoner's state of mind. And as these two questions appear to us to be more conveniently answered together, we have to submit our opinion to be that the jurors ought to be told in all cases that every man is to be presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes, unless the contrary be proved to their satisfaction, and that to establish a defence on the ground of insanity, it must be clearly proved that at the time of committing the act, the party accused was labouring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, that's limb 1, or if he did know it, that he did not know what he was doing, did not know he was doing what was wrong. And the mode of putting the latter part of the question to the jury on these occasions has generally been whether the accused at the time of doing the act knew the difference between right and wrong. The limb upon which Mr. Lewis-Ranwell, was acquitted is the second limb. So he knew the nature of his acts. He intended to kill the men because of his delusion that they were paedophiles, but he didn't realise what he was doing was wrong. Then statutory consequences of the verdict have been enacted. And if I could go to tab 1 of the authorities bundle, page 1. You have section 2, sorry, I've said page 5 of the bundle. Tab 1, page 5 of the bundle. The Trial of Lunatics Act 1883 as amended. And wherein any indictment or information, any act or omission is charged against any person as an offence, and it is given in evidence on the trial of such person for that offence that he was insane, so as not to be responsible according to law for his actions at the time when the act was done or omission made, then if it appears to the jury before whom such person is tried that he did the act or made the omission charged, but was insane as aforesaid at the time that he did or made the same, the jury shall return a special verdict that the accused is not guilty by reason of insanity. Relevant to this area, because it's the statute under which applied in the Henderson and Gray case, is the related defence of manslaughter by reason of diminished responsibility. And at tab 2 of the bundle, page 7 of the bundle, you have the Homicide Act 1957, which provided that where a person D who kills or is a party to the killing of another is not to be convicted of murder if D was suffering from an abnormality of mental functioning, which either arose from a recognised medical condition or substantially impaired D's ability to do one or more of the things mentioned in subsection A, and C provides an explanation for D's acts and omissions in doing or being a party to the killing. And those things were to understand the nature of D's conduct, to form a rational judgment, and to exercise self-control. And a person at subsection 3 who, but for that section, would be liable, whether as principal or as accessory, to be convicted of murder, shall be liable instead to be convicted of manslaughter. Then returning to insanity, the Criminal Procedure Insanity Act 1964 is at tab 3 of the bundle, page 12. And that sets out the court's powers at section 5 to deal with persons who are not guilty by reason of insanity, or indeed, under related sections, unfit to plead at the time of the trial. And you'll see at subsection 2 that where the special verdict has been returned, the court shall make, in respect of the accused, a hospital order, with or without a restriction order, a supervision order, or an order for absolute discharge. But at subsection 3, where the offence to which the special verdict or the findings relate is an offence, the sentence for which is fixed by law, and the court have power to make a hospital order, the court shall make a hospital order with a restriction order. And obviously that applies where the offence charged is murder. At section 6 of that act, on page 14 of the bundle, murder is specifically addressed, and it is said that where on a trial for murder the accused contends that at the time of the alleged offence he was insane so as not to be responsible according to law for his actions, or that at the time he was suffering from such abnormality of mental functioning as is specified in subsection 1, section 2 of the Homicide Act, diminished responsibility, the court shall allow the prosecution to adduce or elicit evidence tending to prove the other of those contentions. Then the Mental Health Act...
Just before we leave the 1964 Act, can you remind me what the original wording was of the 1883 Act that was replaced by the verdict not guilty by reason of insanity?
I think it used to be something like, because we'll see in the case law there was a traditional form of verdict, it used to be guilty but insane.
Guilty but insane. I wondered,
yes.
I couldn't remember that. Okay.
What was that?
Mental Health Act 1983 is at tab 4 of the bundle, page 29. And section 37, because as you recall, section 5 directs the making of a hospital order, which has the same meaning as section 37, is the provision that provides for the making of a hospital order, which is essentially the court may order the person's admission to detention in hospital. I don't think it's necessary to take you to the detail of the section, but section 41, which is page 35, deals with the restriction order, and at subsection 3, the special restrictions applicable to a patient in respect of whom a restriction order is in force are that none of the provisions of Part 2 relating to the duration, renewal and expiration of authority of detention shall apply, and the patient shall be continue to be liable to be detained by virtue of the relevant hospital order until he is duly discharged under the said part or absolutely discharged pursuant to sections 42, 73, 74, 75, and none of the provisions in the Act relating to community treatment orders and community patients will apply, and no application shall be made to the appropriate tribunal under particular sections. And at subsection C, the following powers should be exercisable only with the consent of the Secretary of State, namely power to grant leave of absence to the patient, power to transfer the patient, and power to order the discharge of the patients. And the effect, essentially, of a restriction order is that if there's no restriction order, the managers of the hospital or the patient's next of kin can apply to have the patient released or decide to release the patient. If there's a restriction order in place, that cannot happen unless the Secretary of State approves the decision and the Secretary of State takes into account the risk to the public. Or alternatively, the patient may apply to the Mental Health Tribunal for discharge under Section 73 of the Act, that the Secretary of State must be joined in to any such application so that the Secretary of State can be heard and represent the public interest. My ladies and lord, we haven't put in front of you the Criminal Justice Act 2003. We have copies available in court if you want it. But can I just mention section 327 of that act? A person is classified as a violent offender subject to multi-agency public protection arrangements on their release from detention in a secure hospital if found not guilty of murder by reason of insanity and to have done the act charged against them. And I mention that simply as again showing that the public interest in those who receive the special verdict extends even upon release to having them covered under multi-agency public protection arrangements between statutory agencies. We have a copy of it available at section 327. Would you like it?
I think we can find it ourselves.
Thank you. My lady, turning to the case law, the first case I would take the court to is the Attorney General's reference number 3, reported in the Queen's Bench Report 2000 at page 401, and it's at tab 21, or page 422 of the bundle.
Say page 421.
Yes, it doesn't seem to be
No,
right.
that's not right. It comes up as Garnham.
442, I'm sorry. And my lady and my lords, the propositions we derive from this case, before I take you to it, are that an acquittal on the basis of the special verdict is not the same as a full acquittal. And it still involves the commission of acts which can be fairly stigmatized as criminal. And the facts of the case were that the defendant had forced his way into a house with a snooker cue. He was suffering delusions. He was charged with aggravated burglary and affray. He was, at the time, it was common ground, insane. The judge held that that meant he was unable to form a criminal intent and so directed the jury to acquit him. And the Attorney General made a reference of the question of what had to be proved when an inquiry was embarked upon under the Trial of Lunatics Act 1883. And what the Court of Appeal held was that the Crown had to prove the ingredients constituting the actus reus of the crime by showing that the defendant had caused a certain event or that responsibility was to be attributed to him for the existence of a certain state of affairs which was forbidden by the criminal law. but did not need to prove the mens rea of the crime. The judgment was given by Lord Justice Judge, and at B448, letter C, and this may answer my Lord Justice Underhill's questions. He said the former special verdict under the Trial of Lunatics Act 1883, together with the consequent powers of the court, were amended by the Criminal Procedure Insanity Act 1964 and the Criminal Procedure Insanity and the Fitness to Plead Act 1991. Apart from their other effects, these provisions alleviated some of the harsher aspects of the special verdict. As it amounted to an acquittal, there was no right to appeal. Felsted and the King. Just to mention in passing, that has been remedied now. A person guilty by reason of insanity can appeal to the Court of Appeal. And it's dealt with by sections 12 to 14 of the Criminal Appeal Act 1968, giving that right of appeal. Some of these considerations were repeated in the Queen and Duke, in the context of the then new defence to murder introduced by the Homicide Act 1957, diminished responsibility. The jury returned a verdict as follows: guilty of manslaughter but insane, not guilty of capital murder. We do not know the basis on which the jury reached the conclusion that the killing of the victim, who was shot dead by the defendant, amounted to manslaughter rather than murder. This court, presided over by Lord Parker CJ, approved the form of verdict entered by the judge in accordance with existing practice, guilty of the act charged, but insane at the time of its commission. And I think that may answer my Lord's question. Lord Parker CJ described this as the ordinary form of verdict, adding that the court was not satisfied that the verdict in the form returned by the jury was necessarily wrong. In other words, although the actus reus of murder was established, the court was not required to reject a verdict defining the defendant's action in terms of manslaughter. No less significant, the consequence of the special verdict was that the defendant became a criminal lunatic to be hospitalised, usually in Broadmoor, for an indeterminate period. For an individual who represented no danger to the public, for example, for a petty thief of utter mental simplicity, the mandatory order would be wholly disproportionate. Indeed, Sullivan himself, C.R. and Sullivan, pleaded guilty to assault occasioning actual bodily harm, despite contradicted evidence that as a result of psychomotor epilepsy, he was in law insane at the time of his actions. The sentence on his conviction, a probation order with medical supervision, represented an altogether more advantageous outcome than the order which the court would have been obliged to make if the defence of insanity had been established. The traditional form of verdict reflected the plain distinction drawn in the courts between the actus reus of the offence and the defendant's state of mind at the time of his actions. As Lord Reading explained in Felsted and the King, decided soon after the Criminal Appeal Act 1907, the special verdict under the Act of 1883 resulted in an acquittal because, despite proof of the act charge, the offence had not been committed. As a result of insanity, the defendant was not to be responsible according to law for his actions at the time he did the act. To remove any possible misunderstanding about what he meant, Lord Reading said, "This verdict means that upon the facts proved, the jury would have found him guilty of the offence had it not been established to their satisfaction that at the time he was at the time not responsible for his actions and therefore could not have acted with a felonious or malicious mind. The indictment was for feloniously and maliciously wounding Lillian Ann Felsted with intent to do some grievous bodily harm. It is obvious that if he was insane at the time of committing the act, he would not have had a mens rea, and his state of mind could not then have been that which is involved in the use of the term feloniously or maliciously." This speech was in effect adopted by each member of the House of Lords, and unless the statutory framework of the 1883 Act has been altered by any subsequent legislation, which in our judgment it is not, Felsted and the King remains good authority binding on this court. And Lord Reading's observations highlight two distinct features of insanity cases. First, proof of mens rea is superfluous, and second, arising from the observation that but for his insanity, the defendant would have been guilty of the offence, that it would not have been sufficient for the jury to have been satisfied merely that the defendant caused the victim's wound. The Criminal Procedure Insanity Act 1964 amended the form of special verdict without altering the statutory ingredients of such a verdict under the Act of 1883. The acts or omissions constituting the offence had to be established. The special verdict related to the defendant's state of mind at the time of the offence. Interestingly, Section 6 resolved one of the problems identified in R and Duke by providing that where on a trial for murder the accused contends, A, that at the time of the alleged offence he was insane, so as not to be responsible according to law for his actions, or that at the time he was suffering from some abnormality of mind. This statutory provision reflected the essential framework of the Act of 1883 by maintaining the distinction between the physical act or actions and the defendant's state of mind at the time when he carried them out. The alleged offence, murder, suggests that attention is not restricted to consideration of the killing or death, but extends to the killing or death in circumstances which would amount to murder. At page 450 of the bundle, letter B, His Lordship said, apart from amending some of the provisions relating to special verdicts, the current arrangements for trials where the defendants have been found unfit to plead are now provided by the Criminal Procedure Insanity and Unfitness to Plead Act 1991, in language which echoes not the Criminal Lunatics Act 1800, but the Act of 1883. The jury must decide whether it has been proved that the defendant did the act or made the omission charged against them as the offence, and if so, the jury should find accordingly. Unless the actus reus of the alleged offence is proved, a verdict of acquittal, not a special verdict, will follow. And then at page 451, at the bottom of the page, Lord Justice Judge said, accordingly, the judge's reasoning in the present case was wrong. This does not quite answer the question posed in the reference. Despite the potential difficulties illustrated by counsel in their arguments, the advantages of certainty, and the impossibility of providing a definitive answer to every conceivable case which may arise, in our judgment, the criminal law should distinguish between providing for the safety of the public from those who are proved to have acted in a way which, but for their mental disability, would have made them liable to be convicted and sentenced in criminals, and those whose minds, however disturbed, have done nothing wrong. So far as the criminal courts are concerned, we do not accept that public safety considerations can properly be deployed to justify the making of orders against those who have done nothing, which can be fairly be stigmatized as a criminal act. Our concerns can readily be illustrated by practical examples. A person with mental disability swimming in an overcrowded public pool should not be at risk of the consequences of a finding of insanity when the alleged indecent touching of another swimmer may well have been accidental or non-deliberate. On the other hand, where an apparently deliberate touching takes place in what on the face of it are circumstances of indecency, the individual in question, arguing that he was insane at the time, should not avoid the appropriate verdict on the basis of his own mistaken perception or lack of understanding, or indeed any defences arising from his own state of mind. The difficulties are, if anything, greater where the alleged crime is more serious, where on an indictment for rape it is proved that sexual intercourse has taken place without the consent of the woman and the defendant has established insanity, he should not be entitled to an acquittal on the basis that he mistakenly but insanely understood or believed that she was consenting. But when an individual surrounded by a group of much larger, aggressive and armed youths strikes out and lands a blow on one of them, who unfortunately falls to the ground, sustaining a fatal head injury, it would be unjust if he were prevented from inviting the jury to consider that his violence might have been lawful merely because, as a result of insanity, he believed that the group of youths was a mob of devils attacking him because, as the defendant in the present case believed, he was Jesus Christ. Excluding this individual's own damaged mental faculty at the time, the jury might conclude that although he caused death, his actions were not unlawful and so did not constitute the actus reus of murder or manslaughter. The next case, my lady, I propose to go to is Loke and the DPP. And this case is authority for the proposition that a person who, as Mr. Lewis-Ranwell was, is acquitted on limb 2 of Norton may nonetheless, indeed most likely will have had, full mens rea for the offence. The Loke and the DPP is at tab 31 of the bundle, that's page 822. It's 2017 EWHC 2855, or reported in the Queen's Bench reports for 2018 at 998.
Sorry, I got sight behind which tab?
Tab 31, I hope. It's page 822 of the bundle. And this is a decision of the Divisional Court. The issue was whether the defence of insanity was available to a defendant charged under the Protection from Harassment Act of 1997. And the reason it arose as an issue is that the test of harassment under that act, as this court will know, is objective. And the judgment of the Divisional Court was given by Lord Justice Irwin. And at page 829 of the bundle, at paragraph 22, having, I should say, before that set out an interesting historical analysis of the insanity defence, but I won't take the court to that, an interesting history of it. He said, paragraph 22, in relation to the first limb, not knowing the nature and quality of his act refers to the physical nature and quality of his act and not to its moral or legal quality. In relation to the second limb, Arend Cordar and Arend Windle and Arend Johnson established that he did not know what he was doing was wrong, means legally wrong, not morally wrong. Thus, if a person does something knowing it is legally wrong, but believing it is nonetheless morally justified, he will not succeed on the plea of insanity. And then at paragraphs 34 to 36 on page 832, His Lordship said, this is page 832, paragraph 34, in order to resolve the issues arising in this appeal, it is important to consider closely how the defence of insanity operates so as to relieve the defendant of the criminal liability which would otherwise attach to him by reason of his actions. At the heart of the rationale for the insanity defence is the principle that criminal punishment should only be imposed. Criminal punishment should only be imposed upon those who are responsible for their conduct. As Professor Hart put it in Punishment and Responsibility in 1968, what is crucial is that those whom we punish should have had, when they acted, the normal capacities, physical and mental, for doing what the law requires and abstaining from what it forbids, and a fair opportunity to exercise these capacities. Where these capacities and opportunities are absent, as they are in different ways in the varied cases of accident, mistake, paralysis, reflex action, coercion, it's insanity, etc., the moral protest is that it is morally wrong to punish because he could not have helped it, or he could have not done otherwise, or he had no real choice. The defence of insanity operates so as to give effect to this principle, firstly by relieving the defendant of responsibility in cases where he did not know the nature and quality of his act. In modern terms, this simply means that the defendant literally did not know what he was doing. And then in paragraph 39, down the page, on page 833, in virtually every case where the defendant proves that he did not know the nature and quality of his act at the time he performed it, then he will not be criminally responsible, irrespective of the first limb of the Norton test, because he will lack the mens rea for the alleged offence. The woman who squeezes her husband's throat, believing she is strangling a deadly snake, does not have the mens rea for murder, because she lacks the necessary intention to kill or cause really serious harm. See Glanville and Williams' textbook of criminal law. To that extent, insanity as it operates in that context adds little, in the sense that the defendant would fall to be acquitted of murder in any event by reason of lack of mens rea, although the effect of the special verdict might be that the disposal is different. It is not correct, however, simply to regard insanity reductively as operating simply on the basis that someone who is suffering from a disease of mind will always lack mens rea for the offence. It is possible for someone to have the full mens rea for a criminal offence, whilst at the same time, because of a defect of reason arising from a disease of the mind, not knowing what he is doing is wrong. If a man intentionally kills his wife because he is deluded, because of his deluded belief that he is under threat from a representative of Satan and has received a divine order to slay, and that it is lawful to comply with divine orders, then he possesses the mens rea for murder, but is not guilty of murder because he does not know what he is doing is unlawful, and there is ample support for this proposition. There's a further passage that's been sidelined by someone, so I'll invite you to read that to yourselves, if I may. My lady, the next case from the criminal law I was going to go to is really more about relevance of relation to its recent consideration of the recent consideration of the defence of insanity in the criminal law by this court. Since it is a recent case, I thought I'd mention it. It's R and Keel, and it's at page 999 of the bundle, which is
Which tab?
36.
Yeah, 36, thank you.
Thank
What the case really illustrates is the narrowness of the insanity defence, and some might say it's arbitrariness. But this court felt bound by it. The facts were that there was a frenzied attack carried out by the defendant on his father and mother and grandmother. The evidence was that he did know what he was doing was wrong. However, by reason of his psychotic and deluded state, he believed that he was compelled to act as he did. His body was being used as an agent by the devil, and he believed he had no control over it and no choice but to act as he did. And this court held that the insanity defence was not available. I don't think there's any need to go beyond the head note. But this court held that in order to establish the defence of insanity on the grounds of not knowing that the act was wrong, the defendant had to establish both he did not know his act was A, unlawful, i.e. contrary to law, and B, morally wrong or wrong by the standards of ordinary people. And although it was necessary to assess the defendant by reference to the facts as perceived through the delusion from which he was suffering, that did not obviate the need to consider the primary question of knowledge of wrongdoing, that it was not the case that in principle the concept of knowledge or being conscious of wrongdoing necessarily imported choice or agency, nor was it the case that unless the McNaughton rules comprised an element of choice, the availability of the defence would depend upon the nature of the delusion, that the defence of insanity as at present did not include an element reflecting lack of capacity to control one's action, a defence of irresistible impulse, recommendations to the contrary not having been implemented by legislation, and any proposed changes to the defence which would be laden with policy choices was a matter for Parliament, and it followed that the defence of insanity under the McNaughton rules was not available to a defendant who, although he knew what he was doing was wrong, believed he had no choice but to commit the act in question. That therefore the conviction was upheld. My lady, I've drawn the court's attention to a case which we have found on further research for this appeal in relation to coronial law, which we haven't, I'm afraid, got in the bundle. Just so that the court can see how the case is O'Connor.
Thank you very much.
The case is the Queen and O'Connor, Queen ex parte O'Connor, sorry, against the Avon coroner, Visser intervening, reported in the 2011 Queen's Bench reports at 106. And the facts are set out in the headnote that the claimant, or sorry, the applicant, whilst on holidays, had pushed his children off a hotel balcony and thrown himself after them. And their son had died on the base from his injuries. The father was tried for manslaughter in Greece and acquitted on the basis of that he'd been suffering from temporary psychosis. It's a rather unusual situation because usually there wouldn't be an inquest if a trial had happened in this country in these circumstances. But at an inquest into the son's death in this country, the coroner delivered a verdict of unlawful killing. The claimant, the father's sister, acting as his litigation friend, sought judicial review of the verdict and an order substituting a narrative verdict describing the circumstances of the death. The coroner did not seek to uphold his verdict, acknowledging that he had erred in law and that he had treated as irrelevant the mental state of the father and his capacity to understand the acts. And as the headnote notes, but I'll take you to the paragraphs, paragraph 6 sets out essentially, paragraph 6 and 9 essentially set out the basis of that finding. Paragraph 6 of the judgment of Sir Anthony May. A coroner's inquisition has, by section 11.5b of the Coroner's Act 1988, to set out, so far as such particulars have been proved, how, when and where the deceased came by his death, and by section 11.6, where a person came by his death by murder, manslaughter, or infanticide, the purpose of the inquest is not to include the finding of any person guilty of the murder, manslaughter, or infanticide. A coroner's inquisition shall in no case charge a person with any of those offences. The historical antecedents of this section include that before 1977, a coroner's inquisition finding homicide operated as an indictment of the person so charged, who would be committed for trial upon the inquisition in the criminal courts. This power was abolished by Section 56(1) of the Criminal Law Act 1977 on the recommendation of a committee chaired by Mr. Norman Broderick, QC. A conclusion of unlawful killing then introduced was not intended to indicate even a prima facie case of criminal liability. It was to enable the judgment-neutral fact of how the deceased came by his death to be recorded. It was hoped to turn the verdict into a purely factual record. See Jervis on coroners. Thus, Rule 42 of the Coroner's Rules provides that no verdict is to be framed in such a way as to appear to determine the question of criminal liability on the part of a named person or civil liability. In paragraph 9, although there is surprisingly little direct authority on the point, a coroner's verdict of unlawful killing necessarily predicates a finding equivalent to that required for a conviction of at least manslaughter in a criminal trial. And authorities, including the Queen in West London, coroner ex parte Gray, established that an inquest's conclusions of unlawful killing cannot be reached unless the coroner or jury are so satisfied to the criminal standard of proof. As Watkins LJ said, it was unthinkable a coroner's jury should find a commission, although not identifying the offender of a criminal offence, without being satisfied beyond any reasonable doubt. As that is the background to that. And then at paragraph 13, his lordship commented, it is agreed that notwithstanding the earlier and largely correct reference to the Director of Prosecutions in Newbury, the coroner's reasoning then proceeded on a material misdirection of law, in that A, the test for unlawful killing is not exclusively objective, it being necessary to find at least the mental element necessary for an assault, and B, the defence of insanity is not irrelevant for the purposes of the coroner's verdict. If Mr. Hogan was legally insane when he pushed Liam from the balcony, he would not have been found guilty of murder by reason of insanity in an English criminal court.
So sorry, where are you reading?
Paragraph 13, page
13.
113.
Yes, thank you. Got it.
And a coroner's conclusion of unlawful killing would have been no more available than if the pushing had been an accident. So that's criminal law, coronial law. Now I turn to civil insanity and the civil law. And the position here is that in the civil law is that an insanity, at least in the case where the defendant knew what he was doing, insanity, at least in the case where the defendant intended to do what he was doing.
Sorry.
Insanity, at least in the case where the defendant knew what he was intending. Insanity, at least in the case where the defendant intended to do what he did, is not a defence, even if the defendant did not know that what he was doing was wrong. A person remains responsible in civil law for their actions. And the first authority for that is tab 9. Morrison Marsden at page 72 of the bundle.
Which page did you say?
Page 72 of the bundle, tab 9, Morrison Marsden. This report is from the 1952 All England Reports,
Yes.
page 925. And the facts are very shortly stated in the headnote. The defendant, while suffering from mental disease, attacked and injured the plaintiff. At the material time, owing to disease of the mind, while he knew the nature and quality of his act, he did not know what he was doing was wrong. And there was an action brought for assault and battery, and it was held that as the defendant knew the nature and quality of his tortious act, he was liable for damages for it, even though he did not know what he was doing was wrong. And Stable J's reasoning on the point was brief, but it's been accepted in later cases. At page 73, sorry, page 75, page 75, letters E to F. He said the next matter to consider is whether, granted that the defendant knew the nature and quality of his act, it is a defence in this action that, owing to material infirmity, he was incapable of knowing that his act was wrong. If the basis of liability be that it depends not on the injury to victim but on the culpability of the wrongdoer, there's considerable force in the argument that it is. I have come to the conclusion that knowledge of wrongdoing is an immaterial averment, and that where there is the capacity to know the nature and quality of the act, that is sufficient, although the mind directing the hand that did the wrong was diseased. I turn next to Williams and Williams, which is at tab 11 of the bundle, page 92. It's a divorce case of family jurisdiction.
Which page do you say?
Page 92. Williams and Williams, tab 11, and it's the reports taken from the 1964 appeal cases at 698. And this was a case where the wife wanted dissolution of her marriage on ground of cruelty. And the cruelty resulted from her husband's mental disorder. And the evidence was he knew what he was doing, which was essentially making lots of false accusations against her, but did not know what he was doing was wrong. And by a majority, the court held that insanity was not an answer to the question of cruelty. Cruelty was to be judged with reference to the character and gravity of the acts. And the court also held that the McNaughton rules didn't apply in family proceedings. At page 116 of the bundle, in Lord Reed's judgment, because he was one of the majority of the three judgments I'm going to go to the majority judgments. At the bottom of page 116, the last paragraph, he said, "It is often untrue that such a man is able to exert his reason so as to control his acts in the normal way, or even that he is capable of forming a rational decision about them. Yet these are often the cases where the other spouse is most in need of protection. It is difficult in some of these cases to attribute more than a speck or scintilla of blame to the respondent, in the sense that he, not the reasonable man, ought to have realized the consequences of what he was doing and could have done otherwise if he had tried. If we are to make culpability an essential element in cruelty, we can really only bring in these people by deeming them to have qualities and abilities which the evidence shows that they do not possess. Surely it is much more satisfactory to accept the fact that the test of culpability has broken down, and not to treat entirely differently two people, one of whom is just short of and the other just over the invisible line which separates abnormality from insanity."
And that seems to be on the basis of the public interest in the protection of the injured,
Yes.
literally injured party,
Yes.
outweighs the normal or overlays the normal approach
Yes.
that would apply.
Yes, it does. Although I do submit that there is something in the point he makes that could be said in a case like this, where you have somebody who just gets over the line into the rather controversial McNaughton criteria, as opposed to someone like, say, Ms. Henderson, who also, the judge says, bears no significant responsibility, has exactly the same disposal, but is unable to get over that line, this invisible line. Lord Evershed at page 125. In just above the sidelined passage, said, I do, however, conclude that generally speaking, the conduct of the party charged will not fail to be properly described as cruel, merely because he or she is unaware of the nature and quality of his or her conduct. Certainly, if the conduct is regarded from the point of view of the sufferer, it would not in the ordinary case be said that he or she was not cruelly treated, or indeed that the party charged did not in fact act cruelly, though no doubt unhappily, he or she was through insanity morally blameless. And at page 126, he said, but whatever be the true and just answer to the question, whether a husband or a wife has treated his or her spouse with cruelty, if he or she is through insanity unaware of the nature and quality of the acts complained of, I confess I have no doubt that it can be no answer to a charge of cruelty on his or her part, that knowing the nature and quality of his or her acts, he or she is through insanity unaware that those acts are wrong. In other words, if the person charged with cruelty knows what he is doing, knows, that is to say, the nature and quality of his acts, then it is for the court or the jury to say that where the other party has been in truth cruelly treated thereby, and it will be no answer for the actor to say he did what he did or failed to do what he ought to have done because he was justified on account of some hallucinations based on insanity, or because he otherwise did in truth assume the facts to be such as would or might have justified his conduct. And it's the next sentence I particularly rely on. In such event, it does seem to me that even if the test of inexcusability be applied, his or her conduct will truly and fairly be said to be inexcusable, though it may be, perhaps, be explicable. Finally, I mentioned it because Lord Pearce considered Morrison Marsden. Lord Pearce, at page 144 of the bundle, page 144, Lord Pearce said, a criminal court cannot disregard the diseased mental condition of the man whom it is proposing to punish. It is a duty to punish, but it can grant to the insane any immunity that is consistent with that duty, and no individual hardship is thereby created. The criminal courts in 1843 adopted the McNaughton rules as the best solution to their problem, but the working of those rules is dependent on medical opinions which change with advancing knowledge, and in practice they have given rise to doubt and dissatisfaction. In the civil common law courts, the problem is different. Immunity to an insane person can only be granted at the expense of an injured party, and the balance of hardship at once arises. And in 1616, it was said if a lunatic hurt a man, he should be answerable in trespass. Divergent views, say Professor Fleming in his book of the Law of Torts, have been expressed on whether this stringent approach should be modified in conformity with the change in theory regarding liability for trespass. The footnote says, see Salmond, Winfield and Pollock. He points out that the New Zealand court in Donaghy and Brennan favoured the more stringent view, but in New South Wales, immunity was extended to a defendant in terms of the McNaughton rules. Marsden followed in Beales and Hayward. Stable J steered a course between these extremes and awarded damages for assault against the defendant of unsound mind, deriving sufficient intent on the defendant's part from the fact that his mind directed the blows which he struck. This conclusion, says Professor Fleming, is shared by the better reasoned American cases and has the merit of neither giving undue scope to the defence of insanity nor departing from the modern basis of liability for trespass, which, as we have seen, requires intentional or negligent conduct by the actor. And then finally, in relation to how insanity is treated in the civil law, I've referred to Dunnage and Randall, which is at tab 27, page 600 of the bundle. And the facts were that a visitor to the claimant's home had been acting under a florid, paranoid schizophrenic episode and set on fire to himself with petrol and died at the scene. And the claimant was badly burned, and the claimant then sought damages. The main issue in the case was coverage under an accidental bodily injury insurance policy case. But I just draw attention to the remarks of Lady Justice Arden, as she then was, at B633. Page 633 of the bundle, where she said the case was indistinguishable from Morris and Marden. Paragraph 146.
Yes.
And then at paragraph 635, page 635, paragraph 153, which is sidelined.
Does she refer elsewhere to the case of Mansfield referred to there? If not, can you happen to know what sort of a case that was?
The honest truth is I can't remember. I've read it. I can't remember. Can I come back to you on that later?
Yes, it may be a red herring, but I was just puzzled by that reference, so I'd be grateful.
I should have said her judgment was agreed to as well by Sir Geoffrey Voss. But he also agreed with the judgment of Lady Justice Rafferty. Oh, paragraph 147, Mr. Harding helpfully tells me she refers to Mansfield. Paragraph 147, page 633 of the bundle.
Thank you.
Immediately after Morris and Marsden.
Yes, that's right, Mansfield and Weetabix. It was a hypothetical attack, and the defendant was found not liable because it was
referred to in paragraph 97 in the judgment of Lady Justice Rafferty.
But my lady, that concludes my summary of taking the court through how insanity is viewed, both in the, first of all, in the criminal law, then colonial law, then civil law. Against that background,
There is, I don't want to slow you up, but there is reference to some academic literature in Lady Justice Rafferty's judgment on insanity as a tort defence.
I'm very happy to say that my learned friend for the Health Trust, Miss Ailing, has volunteered that she'll address the court on the academic literature.
Yes, I don't think either of the cases, either of the articles I looked at when I took into the bundle weren't nearly all about criminal academic,
No.
but the nature of insanity is criminal law.
Yes. I think she's proposing to take your lordships and my ladies to Professor Hart and Professor Gardner. And
Yes, quite, but that's all about crime.
Yeah.
I mean, this is of interest because it's
yes.
about insanity as a defence in tort law,
yes.
which might be thought to be rather closer to what we're concerned with in this case.
Can we have a look into that and come back
Yes.
to you on that?
Thank
We're
you.
very fortunate to have Mr. Goodcamp behind my learned friend.
Yes.
Thank you.
We will come back to that, of course. We'll look into that. My lady, in relation to turning then to the recent case law on the illegality defence, I was proposing to start with Grey and Thames Trains, which is tab 22, page 453 of the bundle. And the facts were that in this case, the claimant suffered a psychiatric injury, post-traumatic stress disorder, which was caused by the negligence of the defendants, who were a train company and the operator of rail infrastructure. It was the Ladbroke Grove crash. He was a passenger. He suffered psychiatric injury as a result. And while labouring under his PTSD, he killed a man in a road rage incident. And he pleaded guilty to manslaughter on the grounds of diminished responsibility. And he was ordered to be detained in hospital under Section 37 of the Mental Health Act with a restriction order under Section 41. And he sought to recover damages for loss of earnings consequential to his detention and beyond it, loss of liberty, damage to reputation, feelings of guilt and remorse. And the defendants contended that his claims were barred by the illegality rule, or ex terpi causa. There were three substantive judgments in the House of Lords. Lord Hoffman's and Lord Rogers are the ones that were generally regarded as the leading ones, they having been endorsed by other members of the court. But at page 477, I take you first to Lord Phillips' judgment. He gave a shorter judgment. And you'll see at paragraph 1, he agreed, in fact, with Lord Hoffman and Lord Roger. At paragraph 10 of his speech, I should say, since it was the House of Lords, at page 479 of the bundle, paragraph 10, he cited from the judgment of Lord Justice Mustill from a case called R and Birch, 1989 criminal appeals cases, but he cited this passage in marked contrast with the regime under an ordinary hospital order is an order coupled with a restriction on discharge pursuant to Section 41. A restriction order has no existence independently of the hospital order to which it relates. It is not a separate means of disposal. Nevertheless, it fundamentally affects the circumstances in which the patient is detained. No longer is the offender regarded simply as a patient whose interests are paramount. No longer is the control of him handed over unconditionally to the hospital authorities. Instead, the interests of public safety are regarded by transferring the responsibility for discharge from the responsible medical officer and the hospital to the Secretary of State alone before the 30th of September 1983, and now to the Secretary of State and the Mental Health Review Tribunal. A patient who has been subject to a restriction order is likely to be detained for much longer in hospital than one who is not, and will have fewer opportunities for leave of absence. And I draw that to the Court's attention simply as a helpful summary of the nature of a restriction order. At paragraphs 14 to 15, he referred to the fact that he'd been dealing with the history of the sentencing powers available to a judge. And since Mr. Gray had been tried, Section 45A of the 1983 Act had been inserted It's paragraph 13. So the court could now choose to combine a hospital direction with a penal sentence. But in paragraph 14, he said the comments of both Asplin LJ and Lord Bingham recognised that a mentally disordered offender whose mental condition did not satisfy the test of insanity or render him unfit to plead might nonetheless have no significant responsibility for his offence. Furthermore, while a conviction for an offence punishable with imprisonment is necessary to confer jurisdiction on a judge to impose a hospital order under Section 37, the offence leading to that conviction may have no relevance to the decision to make the hospital order. Thus, in R. Deaton, a hospital order with a restriction order unlimited as to time was made in respect of a woman with a psychopathic disorder where her offence was minor criminal damage. And he said, paragraph 15, in such an extreme case where the sentencing judge makes it clear that the defendant's offending behaviour has played no part in the decision to impose the hospital order, it is strongly arguable that the hospital order should be treated as being a consequence of the defendant's mental condition and not of the defendant's criminal act. In that event, the public policy of ex turpi causa would not apply. More difficult is the situation where it is the criminal act of the defendant that demonstrates the need to detain the defendant, both for his own treatment and for the protection of the public. But the judge does not make it clear he does not consider the defendant should bear. So the judge makes it clear that he does not consider that the defendant should bear significant personal responsibility for his crime. I would reserve judgment as to whether ex turpi causa applies in either of those situations, though we did not hear full argument in relation to them. In doing so, I take the same stance as Lord Rogers. Now, this passage, as we will see later, has been looked at by the Supreme Court in Henderson, and essentially the Supreme Court has said that in the second reservation, where the judge expresses the view that the defendant should not bear significant responsibility, the illegality defence nonetheless applies. And the question has been left open in relation to the first qualification, which is a minor offence, where the sentencing judge says the offending behaviour has made no difference. So page 484, we come to Lord Hoffman's judgment.
Just one moment,
Speech.
sorry. Just one moment. Sorry, yes.
At page 484 of the bundle, paragraph 29, I pick up the speech of Lord Hoffman. And at paragraph 29, he said, it must follow from Core's case, which my ladies and my lord will recall as a case about a suicide. It must follow from Core's case that the mere fact that the killing was Mr. Gray's own voluntary and deliberate act is not in itself a reason for excluding the defendant's liability, nor do the appellants say that it is. Their principal argument invokes a special rule of public policy. In its wider form, it is that you cannot recover compensation for loss which you have suffered in consequence of your own criminal act. In its narrower and more specific form, it is that you cannot recover for damage which flows from a loss of liberty, a fine, or other punishment lawfully imposed upon you in consequence of your own unlawful act. In such a case, it is the law which, as a matter of penal policy, causes the damage, and it would be inconsistent for the law to require you to be compensated for that damage. Is there such a rule? The appellants say that there is, and that it is one aspect of a wider principle, that ex turpi causa non oritur actio, or as Lord Mansfield said in Holman and Johnson, ex dolo malo non oritur actio. And he says this tag has been invoked to deny a remedy in a wide range of situations, and a good deal of time was spent in argument, examining diverse cases, and discussing whether the conditions under which the courts had held the maximum applicable in some other kind of case were satisfied. He then refers to Tinsley and Milligan, But then at letter G, in paragraph 30, on page 484, he says, I did not find any of this discussion very helpful. The maxim ex terpi causa expresses not so much a principle as a policy. Furthermore, that policy is not based upon a single justification, but on a group of reasons which vary in different situations. And that's an insight which has found favour in later Supreme Court cases. At paragraph 32 on page 485, His Lordship said, the particular rule for which the appellants contend may, as I said, be stated in a wider or a narrow form. The wider and simpler version is that which was applied by Mr. Justice Flo. You cannot recover for damage which is the consequence of your own criminal act. In its narrower form, it is that you cannot recover for damage which is the consequence of a sentence imposed upon you for a criminal act. I make this distinction between the wider and narrower version of the rule because there is a particular justification for the narrower rule, which does not necessarily apply to the wider version. And His Lordship then went on to consider the narrower rule, looking at Askey and Golden Wine Company Limited, and then paragraph 34, the leading English authority is the decision of the Court of Appeal in Clunas and Camden and Islington Health Authority, 1998 QB 978, in which the plaintiff had been detained in hospital for treatment of a mental disorder, and on the 24th of September 1992 the hospital discharged him, and on the 17th of December 1992 he stabbed a man to death, and he pleaded guilty to manslaughter on the grounds of diminished responsibility and was sentenced, as in this case, to be detained in hospital pursuant to section 37 of the Mental Health Act with an indefinite restriction under section 41. And the plaintiff sued the health authority, alleging it had been negligent in discharging him and not providing adequate aftercare and claiming damages for his loss of liberty. And the health authority applied to strike out the action on the grounds that even assuming it had been negligent, that the plaintiff would not otherwise have committed the manslaughter damages and could not be recovered for the consequences of the plaintiff's own unlawful act. In other words, the health authority relied upon the wider version of the rule. And then he set out the well-known dictum of Lord Justice Beldam, who my learned friend for the Claimant relies on, gave the judgment of the court, accepted that submission. He said, in the present case, the plaintiff has been convicted of a serious criminal offence. In such a case, public policy would, in our judgment, preclude the court from entertaining the plaintiff's claim unless it could be said he did not know the nature and quality of his act, or that what he was doing was wrong. The offence of murder was reduced to one of manslaughter by reason of the plaintiff's mental disorder, but his mental state did not justify a verdict of not guilty by reason of insanity. Consequently, though his responsibility for killing Mr. Zito is diminished, he must be taken to have known what he was doing and that it was wrong. A plea of diminished responsibility accepts the accused's mental responsibility as substantially impaired, but it does not remove liability for the criminal act. And this court ought not to allow itself to be made an instrument to enforce obligations alleged to arise out of the plaintiff's own criminal act. And we would therefore allow the appeal on that ground. And His Lordship then referred to some New South Wales jurisprudence, in particular, cases from Court of Appeal, first of all, in this country, and Moral and British Railways Board, where Clunas was followed. And then picking up his judgment at paragraph 40, he referred to the case of State Rail Authority and New South Wales versus Wegold, which is from the New South Wales law reports, where the plaintiff was seriously injured in an industrial accident caused by the defendant's negligence. And for some months, he received payments of workers' compensation. But when these ceased, he took to supplementing his income by growing and selling marijuana. Is a good way of telling a story, Lord Hoffman. This was a criminal offence for which he was convicted and served some 8 months imprisonment. He also lost his employment. He claimed compensation for loss of earnings while in prison and afterwards on the ground that it was a consequence of the impecuniosity caused by the accident. By a majority, Samuels and Handley, JJA, Kirby, P dissenting, this damage was held to be irrecoverable. And Samuels, JA, said if the plaintiff has been convicted and sentenced for a crime, it means that the criminal law has taken him to be responsible for his actions and has imposed an appropriate penalty. He or she should therefore bear the consequences of the punishment, both direct and indirect. If the law of negligence were to say in effect that the offender was not responsible for his actions and should be compensated by the tortfeasor, it would set the determination of the criminal court at naught. It would generate the sort of clash between civil and common law that's apt to bring the law into disrepute. And he said, Lord Hoffman said, the narrower rule is thus well established, and the only cases where it's been questioned are those in which some judges have felt it was hard on the plaintiff because his conduct had not been as blameworthy as all that. And he then gives an extreme example as being Kirby P's dissent in the case we've just looked at, which appears to have been on the ground that there was no single view in the Australian community concerning the moral disapprobation of the respondent's conduct in cultivating Indian hemp. And he then set out that likewise it has been submitted in this case that the sentence of detention in the hospital reflected the fact that he was not really being punished, but detained for his own good to enable him to be treated for PTSD. But the sentence imposed by the court for a criminal offence is usually for a variety of purposes: punishment, treatment, reform, deterrence, protection of the public against the possibility of further offences. It would be impossible to make distinctions on the basis of what appeared to be its predominant purpose. In my view, it must be assumed that the sentence in this case, the restriction order, was what the criminal court regarded as appropriate to reflect personal responsibility of the accused for the crime he committed. As one commentator has said, tort law has enough on its plate without having to play the criminal law's conscience. And then at paragraph 42, it should be noticed that in Hunter Area Health Service and Presland, 2005, New South Wales law reports, the New South Wales Court of Appeal, again by a majority, Scheller and Santo, JA, Spiegelman, CJ dissenting, went even further and applied the rule when the plaintiff, who had been negligently discharged from a psychiatric hospital, was acquitted of murdering a woman 6 hours later on the ground of mental illness, but ordered to be detained in strict custody as a mental patient. There are dicta, for example, in the passage I have quoted from Clunis's case, which suggests that the rule does not apply when the plaintiff, by reason of insanity, is not responsible for his actions. But the majority regarded compensation, even in such a case, as contrary to public policy. Scheller JA made the pertinent observation, at paragraph 300, that if the rule did not apply and the plaintiff had killed the negligent psychiatrist who discharged him, the latter's estate would have been liable to pay the plaintiff compensation for his consequent detention. This case, which Scheller J, para 294, described as unusual, if not unique, raises an interesting question about the limits of the rule, which it is not necessary to decide for the purposes of this appeal, and that's why we respectfully say that this point is clearly open. And at paragraph 44, having referred to where Lord Hoffman took the view that the Court of Appeal in that case had gone astray, he said that the court, in relation to the Court of Appeal's judgment, that this argument treats the whole question as being whether the crime can be said to have been caused by the tort. As I have said, there is no dispute that there was a causal connection between the tort and the killing. The evidence which the judge accepted was that, but for the tort, Mr. Gray would not have killed. But the rule of public policy invoked in this case is not based upon some primitive psychology which deems mental stress to be incapable of having a connection with subsequent criminal acts. As Hunter Area Health Service in Presland shows, it may reflect more than one facet of public policy, but it is sufficient in the present case to say that the case against compensating Mr. Gray for his loss of liberty is based upon the inconsistency of requiring someone to be compensated for a sentence imposed because of his own personal responsibility for a criminal act. The Court of Appeal had nothing to say about this aspect of the matter. And then at paragraphs 50 and 51, His Lordship returned to the wider version of the rule, and he said, "My Lords, that in my opinion is sufficient to dispose of most of the claims which are the subject of this appeal. Mr. Gray's claims for loss of earnings after his arrest and for general damages for his detention, conviction, and damage to reputation are all claims for damage caused by the lawful sentence imposed upon him for manslaughter, and therefore fall within the narrower version of the rule, which I would invite your Lordships to affirm. But there are some additional claims which may be more difficult to bring within this rule, such as the claim for an indemnity against any claims which might be brought by the dependents of the dead pedestrian, and the claim for general damages for feelings of guilt and remorse consequent upon the killing. Neither of these was the consequence of the sentence of the criminal court. I must therefore examine a wider version of the rule, which was applied by J. This has the support of the reasoning of the Court of Appeal in Clunis's case, as well as other authorities. It differs from the narrower version in at least two respects. First, it cannot, as it seems to me, be justified on the grounds of inconsistency in the same way as the narrower rule. Instead, the wider rule has to be justified on the grounds that it is offensive to public notions of fair distribution of resources, that a claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. Secondly, the wider rule may raise problems of causation which cannot arise in connection with the narrower rule. The sentence of the court is plainly a consequence of the criminality for which the claimant was responsible, but other forms of damage may give rise to questions about whether they can properly be said to have been caused by the criminal conduct. And His Lordship then examined the cases on the difference between having the opportunity to do something and something being the cause of something. I should say that the Supreme Court in Henderson were later to say that, in fact, the inconsistency was a factor in both the narrower and the wider rule, although Lord Hoffman had expressed it as not being such here. But they also endorsed Lord Hoffman's identification of the policy about matters being offensive to public notions of the fair distribution of resources. Lord Rogers at page 498 of the bundle, if I could just go to that in his judgment, because it was the bit that Lord Phillips was agreeing with, and also has a helpful passage in relation to the inconsistency in relation to disposal and sentence. At paragraph 78, he said, after he killed Mr. Boltwood, the claimant was detained, first in prison and then in Ranwell Hospital, in accordance with a number of orders of the criminal courts. He did not challenge any of those orders. Civil courts must therefore proceed on the basis that, even though the claimant's responsibility for killing Mr. Boltwood was diminished by the PTSD, he nevertheless knew what he was doing when he killed him, and he was responsible for what he did. Similarly, it must be assumed that the disposals adopted by the criminal courts were appropriate in all the circumstances, including the circumstance that he was suffering from PTSD. Rafferty J. imposed a hospital order and a restriction order. While it is correct to say that a hospital order, even with a restriction, is not regarded as a punishment, this does not mean the judge was treating the claimant as not being to blame for what he did. On the contrary, as the Court of Appeal recalled in R. and Birch, even where there is culpability, a hospital order with a restriction order may well be the appropriate way to deal with a dangerous and disordered person. We must therefore proceed on the basis that Rafferty J correctly considered that the orders which she made were necessary for the protection of the public from serious harm, having regard in particular to the claimant's violent attack on Mr. Boltwood. And by imposing the hospital order with a restriction, the judge was ensuring that, because he had committed manslaughter, the claimant would not be free to move around in the community unless and until authorised to do so by the Secretary of State. This meant, among other things, that he was not to be free to work and earn while subject to the orders. In other words, his earning capacity was removed for as long as they were in force. In my view, it would be inconsistent with the policy underlying the making of the orders for a civil court now to award the claimant damages for loss of earnings relating to the period when he was subject to them. So his lordship seems to put forward two bases for that inconsistency, one being it's the sentence that's imposed, the other being that a purpose behind it is its ongoing public protection. The next case I was going to go to was Les Laboratoires Servier and Apotex, which is at page 553. It's a decision of the Supreme Court reported in the 2015 Underhill cases at 430. The facts of this case are somewhat complex. Servier had given a cross undertaking in damages when they obtained an injunction against Apotex based on alleged patent infringement. Both parties were pharmaceutical companies involved in manufacture and sale of drugs. Servier then lost a trial, so there was an inquiry into damages ordered into any losses suffered by Apotex and to be claimed under the cross undertaking. Servier alleged that the damages which were being claimed by Apotex were barred by public policy because the products that Apotex lost the opportunity to sell in the UK by reason of the injunction would have been manufactured in breach of Canadian law, a Canadian court having held that by manufacturing, selling and exporting the drug in question, Apotex had infringed a Canadian patent held by another company within the Servier group. The judge at first instance held that the claim was barred. The Court of Appeal and then the Supreme Court disagreed. And some historical context is necessary for this case because it was decided at a time when the Supreme divisions in the Supreme Court over the nature of the illegality defence were coming to the surface in their judgments, and in particular whether the defence was a purely rules-based one or alternatively whether the defence was policy-driven, with the court having to look at the individual policies at play in a particular case. And the majority in this court were on the rules-based side, and it was Lord Sumption who gave the majority judgment. And his reasoning was that a breach of patents involved essentially only private law interests, and that the relevant illegality did not therefore constitute a turpitude for the purposes of the defence. It's important to note, and I'll take you to it in a minute, that Lord Toulson's reasoning was different. He did not take a blanket approach, that because the only wrongdoing was a civil one, illegality could not apply. He analysed the case in policy terms, as indeed had Sir Terence Etherton in the Court of Appeal. And his approach, Lord Tolson's approach, is the one which, as my ladies and my lord will know, is the approach which prevailed in Patel and Mirza when the Supreme Court convened en masse to resolve this issue. But at on page 561, Lord Sumption summarised the issues which arose and said that the illegality point turns in this case on three issues. Does the infringement of a foreign patent rights constitute a relevant illegality, or, quotes, turpitude for the purposes of the defence? Two, if so, is Apotec seeking to find its claim on it? And three, is Servier entitled to take the public policy point, having given an undertaking in damages? And it's really on the first question that my focus is relevant here. And at paragraph 11 on page 562, His Lordship summarised the approach that the Court of Appeal had taken. And about 3 lines down, he said the Court of Appeal gave judgment allowing the appeal. The leading judgment was given by Lord Justice Etherton, with whom Lord Justice Kitchen and Laws agreed. The essential point on which he differed from the judge was issue 1. In his view, the infringement of Servier's Canadian patent was not a relevant illegality for the purposes of the defence. This was because in dealing with the illegality defence, the court, at paragraph 73, was entitled, quotes, to take into account a wide range of considerations in order to ensure that the defence only applies where it is just and proportionate response to the illegality involved in the light of the policy considerations underlying it. Lord Justice Etherton considered that this test was not satisfied, and then he set out the reasoning behind it, including that if he had been satisfied, having analysed those factors, that the infringement of the Canadian patent was a relevant illegality, he would have upheld the defence. At paragraph 20, Lord Sumption set out his opposition to that sort of range of factors style approach. And that's at the bottom of page 566. Letter G, he referred to the fact that he referred to the Law Commission's Illegality Defence Consultative report, and how they'd observed that a public conscience test, although rejected in Tinsley and Milligo, was nevertheless useful. And at page 567, he said that he found that difficult to justify as an approach. And he said it was inconsistent with Tinsley and Milligan. And at paragraph 21, he said that it follows that the disposition of this case by the Court of Appeal cannot possibly be justified by the considerations put forward by Lord Justice Etherton. Lord Justice Etherton rejected the illegality defence on the ground that the infringement of Servier's Canadian patent was not turpitude for the purposes of the illegality defence. However, he did not address the question as to what, as a matter of principle, turpitude consisted. He rejected the argument of Servier that patent infringement was necessarily turpitude, but also the argument of Apotax that it never was. Instead, he had it all depends on the precise circumstances. And then at paragraph, the reason I mention that, the important point about this is that insofar as the majority of the Supreme Court held, as Lord Sumption did, that a civil wrong could never constitute relevant turpitude outside cases of dishonesty, that isn't in fact the law. One has to apply the policy-based approach. And he asked at paragraph 23, what is turpitude? And he said the paradigm case of an illegal act engaging the defence is a criminal offence. So much so that much judicial analysis deals with the question as if nothing else was relevant. Yet in his famous statement of principle in Holman and Johnson, Chief Justice Mansfield spoke not only of criminal acts, but of immoral or illegal ones. What did he mean by this? I think that what he meant is clear from the characteristics of the rule as he described it, and as judges have always applied it. He meant acts which engage the interests of the state, or as we would put it today, the public interest. The illegality defence, where it arises in the public interest, irrespective of the interests or rights of the parties. It is because the public has its own interest in conduct giving rise to the illegality defence that the judge may be bound to take the point of his own motion, contrary to the ordinary principle in adversarial litigation. In some contexts, notably the invalidity of contracts prohibited by law, the ex turpi causa principle can be analysed as part of the substantive law governing the parties' rights. The contract is void, and any right derived from it is non-existent. But in general, although described as a defence, it is in reality a rule of judicial abstention. It means that rather than regulating the consequences of an illegal act, for example, by restoring the parties to the status quo ante, in the same way as on the rescission of a contract, the courts withhold judicial remedies, leaving the loss to lie where it falls. This is so even in a contractual context, when the court is invited to determine the financial consequences of a contract's voidness for illegality. The ex turpi causa principle precludes the judge from performing his ordinary adjudicative function in a case where that would lend the authority of the estate to the enforcement of an illegal transaction or the determination of the legal consequences of an illegal act. At paragraph 25, he said the ex turpi causa principle is concerned with claims founded on acts which are contrary to the public law of the state and engage the public interest. The paradigm case, as I have said, is a criminal act. In addition, it is concerned with the limited category of acts which, while not necessarily criminal, can be conveniently described as quasi-criminal because they engage the public interest in the same way. Leaving aside the rather special case of contracts prohibited by law, which can give rise to no enforceable rights, this additional category of non-criminal acts giving rise to the defence includes cases of dishonesty or corruption, which have always been regarded as engaging the public interest, even in the context of purely civil disputes. Some anomalous categories of misconduct, such as prostitution, which without itself being criminal are contrary to public policy and involve criminal liability on the part of secondary parties, and the infringement of statutory rules enacted for the protection of the public interest and attracting civil sanctions of a penal character, such as the competition law considered by Flo J and Safeway stores and Twigger. Then at paragraph 28, in relation to his finding and the majority's finding in that case on civil wrongs, he said, apart from these decisions, the researchers of council have uncovered no cases in the long and much litigated history of the illegality defence in which it has been applied to acts which are neither criminal nor quasi-criminal, but merely tortious or in breach of contract. In my opinion, the question what constitutes turpitude for the purpose of the defence depends on the legal character of the acts relied on. It means criminal acts and what I have called quasi-criminal acts. This is because only acts in these categories engage the public interest, which is the foundation of the illegality defence. Torts, other than those of which dishonesty is an essential element, breaches of contract, statutory and other civil wrongs, offend against interests which are essentially private, not public. And there is no reason in such a case for the law to withhold its ordinary remedies. Public interest is sufficiently served by the availability of a system of corrective justice to regulate the consequences between the parties affected. And then at paragraph 29, he says it is right to add that there may be exceptional cases where even criminal and quasi-criminal acts will not constitute turpitude for the purposes of the illegality defence. In Gray and Thames Trains, Lord Roger of Earlsfree suggested that some offences might be too trivial to engage in the defence. In general, however, the exceptional cases are implicit in the rule itself. This applies in particular where the act in question was not in reality the claimant's at all, leaving aside questions of attribution which arise when an agent is involved and in which no part of the present appeal. There is a recognised exception to the category of turpitudinous acts for cases of strict liability, generally arising under statute, where the claimant was not privy to the facts making his act unlawful. See Stones and Rules Limited and Moore Stevens. In such cases, the fact that liability is strict and that the claimant was not aware of the facts making his conduct unlawful may provide a reason for holding that it is not turpitude at all. And since someone has highlighted it, could I invite the court to read to the end of this sidelined passage? And the point we draw to the court's attention in relation to this passage is that the exception that Lord Sumption is postulating in relation to strict liability is one that requires strict liability and knowledge, lack of knowledge. Can I just briefly draw then the court's attention to Lord Tolson's reasoning, because he was in the minority in this case, but later the majority, on the intellectual battle that was waging. He summed up his judgment at paragraph 46, where he said, in this appeal, Servier is attempting to extend the doctrine of illegality beyond any previously reported decisions in circumstances where I see no good public policy reason to do so. So he very much put his thinking in terms of the public policies. And at paragraph 57 on page 576, I should say, first of all, 56, paragraph 56 on page 576, he said there are very few reported cases in which the doctrine of illegality has been applied to tort. He said in Brian Jenkinson and Percy Dalton, the Court of Appeal held a contract to be unenforceable, which had as its object the commission of the tort of deceit. But in that case, Lord Justice Pearce qualified his judgment by saying that in none of the cases cited before the court had a plaintiff failed where he was not fraudulently minded. And fraud for the purposes of deceit includes a false statement made in reckless disregard of whether it be true or false, but there's no precedent for applying the doctrine of illegality to a tort of strict liability. And then at 57, he set out how Servier relied on the statement of Lord Mansfield, and at letter D said the case law is notoriously untidy. In deciding whether the principle should be applied in circumstances not directly covered by well-established authorities, it is right to proceed carefully on a case-by-case basis, considering the policies which underlie the broad principle. And then at paragraph 61 to 63, he set out his analysis of the law and the policies, referring first of all to Hunger and Allen at 61. And at paragraph 62, he said he would therefore make no criticism of the Court of Appeal, which I'm sure must be something courts of appeal like to hear from the Supreme Court, for considering whether public policy considerations merited applying the doctrine of illegality to the facts of the present case.
Can I just ask you a question, which I noted that Lord Sumption referred to the fact that, I think it's at paragraph 13 or 14, that the defence of illegality applies where otherwise the claim would succeed.
Yes.
This case is a strikeout,
It is.
and we're addressing a novel point
Yes.
on your submission. It's a
Yes.
novel point. I think the judge said it was in the application of well-established principles to a slightly different set of circumstances.
Yes.
Either way, we don't have, we have to proceed on the basis of the claimant's case as pleaded.
You do.
But there is a strong line of authority which says in circumstances where there is a novel point, and particularly in a case like this which raises more than one question, it might be said, for example, in relation to causation and so on, which might arise at a later stage depending on the outcome of this appeal, that strikeout is not the right way to proceed.
Well, there are certainly cases along that line, and that has certainly been said in some cases, including cases like Barrett and Enfield, and indeed later cases. On the other hand, it's one of those areas where you can find the dictum that suits your approach. There are other cases where the Supreme Court have, and the House of Lords before them, have said, well, either there is a case on these facts, or there isn't. Claimants pleaded their case at its highest, and either, for instance, in the duty of care context, there is a duty or there isn't. And an example of that is Lord Brown in Bancollen, Chief Constable of Hertfordshire. Again, in the Supreme Court, in a number of cases, including a case I did called James Bowen, the Commissioner of Police for the Metropolis, and recently in this court in a case called Tyndall and Thames Valley Police. So your ladyship is absolutely right. There are dicta which suggests that, but I would pray and aid that actually we have the case as pleaded. We have to proceed on the basis that the claimant will make out the facts alleged, including the allegations of duty and negligence.
Well, we have to on the basis that this is the way some of the defendants have chosen to bring the issue before the court.
Yes.
But looking at the underlying issues, if one reads the defence, for example, one sees various factors which are put into the mix, including whether or not the claimant took his own medication and whether or not he took drugs before, which would be relevant to the issue of responsibility. For example, if one's looking at if this was a case that had to be sentenced as a diminished responsibility offence, those are factors which bear on the issue of responsibility, which is one of the issues we have to look at, being presented as rather a black and white issue here.
That is certainly, those are issues which could arise on the trial. There's no doubt about that. To win, the defendants would have to establish that even on this appeal, the defendants have to proceed on the basis that failure to take medication had nothing to do with it, and that's not an issue which is raised in this appeal. But my lady is right to say that that might be a factor at a trial which would be relevant to the issue of illegality. But the Supreme Court in both Henderson, which my learned friend I know appeared in, and also Stoffel and Grondona, said essentially that the application of the illegality defence and the policies which underlie it are issues which are to be considered at a high level. So it's not a case that evidence could be called in relation to the underlying policies applicable. Indeed, the Supreme Court expressly eschewed that. They said that whether the defence applies or not is to be considered at a high level. So I suppose on this application, we're, say, submitting to the court, even assuming in the claimant's favour that he hadn't failed to take his medication, which is his case, even assuming that the fact of the killings in this case and the fact that they are killings of which he doesn't get a full acquittal in terms of the Attorney General's reference case, but the special verdict with all the public policies behind that is enough to bar the claim, as it was in Hunter and Presland.
And if you could just remind me which of the cases we've looked at have proceeded pre-trial, as it were.
I'm not sure I can offhand. I think Henderson went on.
Yes, perhaps you can just have a think about that over lunch, but not lunch yet. But
I believe
I'm not asking for an instant answer now necessarily.
Yes, judgment was entered for damages to be assessed in Henderson, I think, and it proceeded on the basis of assumed facts.
Perhaps I can assist since I was in the case. So Henderson was perhaps unusual in that liability was admitted at an early stage and judgment was then entered. And then illegality became an issue. And so there were then agreed facts because there was nothing left an issue between the parties. Clunis was certainly a strikeout application. And in Gray, I believe that was also a strikeout application, but Clunis proceeded. It was a duty of, it was a strikeout application.
Yes.
Sorry, I was on Lord Toulson's judgment, and I was just going to say you can see how he weighed the policies in play at paragraph 63 of his judgment. And he concluded that the illegality defence did not arise. Then the next case is Patel and Mertza, which is at tab 29 on page 712.
Could you give me the page reference again?
Yes, it's page 712.
Thank you.
And we have the appeal cases report from 2017, page 467. I don't need to trouble you with the facts. I'm sure you're familiar with them, but it was a non-just enrichment case where money had been paid for insider dealing and the claimant didn't happen and the claimant was suing to get his money back. And at page, Lord Toulson gave the judgment of the majority of the Supreme Court, although all judges agreed that the appeals should be the claim should be allowed. There was a division between those who believed in the rules-based approach and those who believed in the range of factors approach to the issue of illegality. And Lord Toulson gave the judgment to those in favour of the range of factors, which was the majority. And at page 740, he, paragraph 80, set out some of the background. He referred to the fact that after Hunga and Allen came the decision of the Supreme Court in the Laboratory Surveyor and Apotex. The issue of illegality arose in the context of a claim to enforce a cross-undertaking in damages, as we've just seen, and the claim was therefore akin to claim and contract. The facts were somewhat complicated but do not matter. For present purposes, the court held unanimously that the Court of Appeal had reached the right result, but the majority of this court expressed the view that the Court of Appeal's decision could not possibly be justified by the considerations put forward by that court, which had in broad terms followed the approach commended by the Law Commission. I expressed a different view, observing that the Court of Appeal had adopted a similar approach to that taken by this court in Hunga. And then he said after the Laboratory Survey and Apotex came Bilta, there was a sharp division of opinion about the proper approach to the defence of illegality, between on the one hand a strictly rules-based approach and on the other hand a more flexible approach by which the court would look at the policies underlying the doctrine and decide whether they militated in favour of the defence, taking into account a range of potentially relevant factors. The majority did not consider it necessary to resolve the difference in that case, since it did not affect the result. But Lord Neuberger, President of the Supreme Court, said it needed to be addressed as soon as appropriately possible. And then at paragraph 84, he set out one possible version of a rules-based approach, which Tinsley and Milligan and Le Laboratoire Servier could be interpreted as supporting, which is a single master rule based on reliance, and whether you have to rely on the illegality to establish the claim. But at paragraph 93, he set out the alternative approach of a range of factors, which then Professor Burrows, now of course Lord Burrows, suggested, which would read as follows: if the formation of or purpose or performance of a contract involves conduct that is illegal, such as a crime, or contrary to public policy, such as restraint of trade, the contract is unenforceable by one or either party if to deny enforcement would be an appropriate response to that conduct, taking into account where relevant, A, how seriously illegal or contrary to public policy the conduct was, B, whether the party seeking enforcement knew of or intended the conduct, C, how central to the conduct or its performance the conduct was, D, how serious a sanction the denial of enforcement is for the party seeking enforcement, and E, whether denying enforcement will further the purpose of the rule which the conduct has infringed, and F, whether denying enforcement will act as a deterrent to conduct that is illegal or contrary to public policy, and G, whether denying enforcement will ensure that the party seeking enforcement does not profit from the conduct, and H, whether denying enforcement will avoid inconsistency in the law, thereby maintaining the integrity of the legal system. And Professor Burrows noted that the final factor is capable of wider or narrower approach, depending on what one understands by inconsistency. And then at paragraph 99...
Could you just read 94?
Yes, of course. 94, the reference to what is an appropriate response brings to surface the moral dimension underlying the doctrine of illegality, which inevitably influences the minds of judges and peeps out in their judgments from time to time. Tinsley and Milligan caused disquiet to Lord Gough and others precisely because its reasoning jarred with their sense of what was just and appropriate.
Yes, you want to go on to 99?
At paragraph 99, His Lordship said, looking behind the maxims, there are two broad discernible policy reasons for the common law doctrine of illegality as a defence to a civil claim. One is that a person should not be allowed to profit from his own wrongdoing. The other linked consideration is that the law should be coherent and not self-defeating, condoning illegality by giving with the left hand what it takes with the right hand. And Lord Gough, in the Spycatcher case, Attorney General and Guardian newspapers, said that the statement that a man shall not be allowed to profit from his own wrong is in very general terms and does not of itself provide any sure guidance to the solution of a problem in any particular case. In Hall and Herbert from Canada, McLachlan J favoured giving a narrow meaning to profit, but more fundamentally she expressed the view that as a rationale, the statement that a plaintiff will not be allowed to profit from his or her own wrongdoing does not fully explain why particular claims have been rejected, and that it may have the undesirable effect of tempting judges to focus on whether the plaintiff is getting something out of the wrongdoing, rather than on the question of whether allowing recovery for something which was illegal would produce inconsistency and disharmony in the law, and so cause damage to the integrity of the legal system. That is a valuable insight with which I agree. I agree also with Professor Burrows' observation that this expression leaves open what is meant by inconsistency or disharmony in a particular case, but I do not see that as a weakness. It is not a matter which can be determined mechanistically. So how is the court to determine the matter, if not by some mechanistic process? In answer to that question, I would say that one cannot judge whether allowing a claim which is in some way tainted by illegality would be contrary to the public interest because it would be harmful to the integrity of the legal system without A, considering the underlying purpose of the prohibition which is being transgressed, B, considering conversely any other public policies which may be rendered ineffective or less effective by the denial of the claim, and C, keeping in mind the possibility of overkill unless the law is applied with a due sense of proportionality. We are, after all, in the area of public policy, and that trio of necessary considerations can be found in the case law.
And is the reference to proportionality there the reference back to not using it for trivial claims and the like?
That may be one factor that's relevant to that. He gives a further explanation, in fact, of proportionality at paragraph 107, yeah, page 746. I'm sorry, did I speak over someone?
No, I suggested you might look at 108 as an example.
With your ladyship's leave, if I start at 107, he said, in considering whether it be disproportionate to refuse relief to which the claimant would otherwise be entitled, as a matter of public policy, various factors may be relevant. Professor Burrow's list is helpful, but I would not attempt to lay down a prescriptive or definitive list because of the infinite possible variety of cases. Potentially relevant factors include the seriousness of the conduct, its centrality to the contract, whether it was intentional, and whether there was a marked disparity in the parties' respective culpability. The integrity and harmony of the law permit, and I would say require, such flexibility. And part of the harmony of the law is its division of responsibility between the criminal and civil courts and tribunals. Punishment for wrongdoing is the responsibility of the criminal courts, and in some instances statutory regulators. It should also be noted that under the Proceeds of Crime Act 2002, the state has wide powers to confiscate the proceeds of crime, whether on a conviction or without a conviction. Punishment is not generally the function of the civil courts, which are concerned with determining private rights and obligations. The broad principle is not in doubt. Public interest requires that the civil courts should not undermine the effectiveness of the criminal law, but nor should they impose what would amount in substance to an additional penalty disproportionate to the nature and seriousness of the wrongdoing. And Parky now is a good example of a case where denial of a claim had been disproportionate. The claimant did not set out to break the law. If it had realised the letters that it was proposing to send were legally objectionable, the text would have been changed. The illegality did not affect the main performance of the contract. Denial of the claim would have given the defendant a very substantial unjust reward. Respect for the integrity of the legal system is not enhanced if it appears to produce results which are arbitrary, unjust, or disproportionate. And then his lordship summarised his test at paragraph 120. At page 749. The essential rationale of the illegality doctrine is it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system or possibly certain aspects of public morality, the boundaries of which have never been made entirely clear and which do not arise for consideration in this case. In assessing whether the public interest would be harmed in that way, it is necessary, A, to consider the underlying purpose of the prohibition which has been transgressed and whether that purpose will be enhanced by the denial of the claim, B, to consider any other relevant public policy on which the denial of the claim may have an impact, and C, to consider whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. Within that framework, various factors may be relevant, but it would be a mistake to suggest that the court is free to decide a case in an undisciplined way. Public interest is best served by a principled and transparent assessment of the considerations identified, rather than by the application of a formal approach capable of producing results which may appear arbitrary, unjust, or disproportionate. And that's a reference to the fact the Supreme Court overruled by majority Tinsley and Milligan, which had said it all dependent on whether you had to plead an illegality to make out your claim, essentially. My lady, I see the time. I am making good progress. What I've left to do is to go through Henderson then Hunter Area Health and President, and then very briefly our grounds of appeal.
Yes, all right. We'll sit again at 5 to 2 then.
All right.